Wait a few seconds.
Well, I remember a teacher that I had. Now, I went through the 7th grade. I went to the 7th grade. And I left home when I was 10 years old because I was hungry. And I used to, this is true. I work in the summer and I go to school in the winter. But I had this one teacher. He was the principal of the Harrison School in Vincennes, Indiana. To me, this was the greatest teacher, a real sage of my time, anyhow. He had such wisdom. And we were all reciting the Pledge of Allegiance one day. And he walked over, this little old teacher. Mr. Laswell was his name. Mr. Laswell. And he says, he says, I've been listening to you boys and girls recite the Pledge of Allegiance all semester. And it seems as though it's becoming monotonous to you. If I may I recite it and try to explain to you the meaning of each word. I, me, an individual, a committee of one, pledge, dedicate all of my worldly goods to give without self-pity. Allegiance, my love and my devotion to the flag, our standard, Old Glory, a symbol of freedom. Wherever she waves, there's respect, because your loyalty has given her a dignity that shouts freedom is everybody's job. United. That means that we have all come together. States, individual communities that have united into 48 great states. 48 individual communities with pride and dignity and purpose. All divided with imaginary boundaries, yet united to a common purpose. And that's love for country. And to the republic, a state in which sovereign power is invested in representatives chosen by the people to govern. And government is the people. And it's from the people to the leaders, not from the leaders to the people, for which it stands. One nation, meaning so blessed by God, indivisible, incapable of being divided, with liberty, which is freedom, the right of power to live one's own life without threats, fear, or some sort of retaliation. And justice, the principle or qualities of dealing fairly with others. For all, which means, boys and girls, it's as much your country as it is mine. And now, boys and girls, let me hear you recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice for all. Since I was a small boy, 2 states have been added to our country, and 2 words have been added to the Pledge of Allegiance. Under God. Wouldn't it be a pity if someone said that is a prayer and that would be eliminated from schools too?
Thank you for joining us. You are listening to Education by Ed. Today is currently February 18th, 2018. And Ed, why don't you start it off?
Thank you. I'd like to thank everybody for joining us tonight. Clarify we're not lawyers, attorneys, doctors, professionals, any corporate structure that we don't claim. We're not incorporated ourselves. Anyhow, tonight is going to be an interesting topic, and I'm posting around, too, the court case of the Finnegan lawsuit. And that's part of the thing that I want to get into tonight on how to do court cases to the best of my knowledge and others that I've been working with. And the thing is that most people, when they do these court cases, leave out a lot, including criminal charges. And you have to remember, you have to put criminal charges into your cases. When you leave these things open the way this case is looking to be opened, it leaves a lot to be questioned. And it's open where, in my knowledge or my comprehension of learning and the stuff that I've been through, it's opened in such a fashion that the courts can do anything they want, possibly with this case. One situation that I noticed is that they ask for a grand jury, but they don't specify what grand jury they want. Is it a grand jury of the corporate identity of the system itself? See, this is the one thing when you ask for these things and insert your rights for these things, it's your responsibility to insert your rights to the court you want. You don't want a grand jury of the corporation of a maritime corporation, a six-man or six-woman jury. They handpick them. You want a real jury of 12 men and 12 women. And this is the one thing I do encourage people to read and do research on this. Because when you get into this, remember, or comprehend and learn this stuff too, when you get into this stuff, you realize that in 1963, when they did the Uniform Commercial Code, they put everything under Roman Vatican law. And once you start realizing how this thing works and start paying attention how your court system works, because this is where a lot of people start going to these courts and they go, I have rights. Or they say this to a cop on the street, I have rights, you know my rights. Well, a cop doesn't know your rights. He doesn't even know if you're lawful or legal in this country. So you have to know what you are claiming and the circumstances of your rights you're claiming. If you don't claim your rights and comprehend it, then how is somebody supposed to know it? This is the problem that we get into not only with ourselves, but the court system itself. See, this is the thing that gets to me when I'm going through this and the Vatican lawsuit, and they have a class action lawsuit, which I do not encourage class action lawsuits myself, because a class action lawsuit could be thrown out on any type of merit that a judge decides. You don't get the court case unless you pass the judge's table. So, and then they didn't quote into a lot of things, statement of facts. They quoted statement of facts, but where is the statement of facts in this deal? There's no affidavits that have been filed. There's no links or anything to affidavits that to be entered in the court case. That is the other circumstances that I noticed in this filing. It's not presented in such a way where it brings in the evidence. They're referencing to videos. What videos? Whose videos? How many videos? There's no links to the videos. There's no link to the case of the videos. And then they go into the other point of unlawful death. In Black Law Dictionary, in Beauvier, unlawful death basically is a homicide. And that means it's legal by the system. That should have actually said, murder. If it actually said murder, then they have standing on it. But and then it doesn't get into, it says the state. Where's this state? It's comprehending the lawful and legal point. And with the class action, the way it's written, everybody should have done an affidavit, they could have done a class action, but everybody should have done their own individual lawsuit as well with their affidavits intact. Injured party, 18 U.S.C. 3771. That's not even into that. And I've talked to federal judges, and if you go through the federal court procedure, if you don't claim to be a corpus delicti, injured man or woman party, they can dismiss it on that because you're claiming that you're a corporate member, a corporate identity, and this is how they get away throwing court cases out. And then the other point that, when you're going against the black robe priest, they're going into an Article 1 court system is what they have filed. They don't have it as an Article 3 court system. And that's the one thing that, I've sent these people so much information, even with BLM, when BLM attorneys personally admitted in public congressional hearings that BLM has no authority. And that was by their own lawyers stating these facts. And that is the one thing that their own lawyers of BLM have stated facts that I sent them. And I don't see any of that, even in the case where they're referencing to the BLM lawyers stating that they have no authority at all. So this is, I'm just throwing my thoughts and my ideas of what I've read in this court case, and what I see is missing. And there's no separation of the evidence and laid out with the evidence of what happened in the circumstances. There's no, even the coroner's report is not even in the statement, a link to it or anything. So where's the evidence? It's more written like a political structure like the Montana Freeman happened and with the little settlement that they got for killing the woman. Or murdering the woman involved. And that's the one thing that when you do this, and we have it posted up, and I sent this thing to a lot of people, Federal Criminal Procedure by Federal Law, the Federal Administrative Rules. I suggest people read that. All the time I suggest people read this stuff of what the courts do, how the courts proceed. Because when you have lawyers do this, and lawyers that are part of the bar, that's part of the structure, including with acting Governor Kate Brown, you got to really look at these things. The statement of cause, where's the statement of cause outlined? It has a statement of cause, but it's not explained really, it's just highlighted. It's like a chapter in a book the way it comes across to me. And I'm no court expert, and I'm nobody of an expert point of view, but I've read a lot of this stuff. I've been around the courts. I've been around the system off and on for 30, 35 years. I've seen this stuff being laid out. I've listened to judges. I've sat there and talked to a lot of them up at the Oregon State Capitol, and I've asked them questions along the way. And so I listen to what these men and women say. And then the other thing is that they have it where they put Lavoie's they put a trust involved. Well, that's an open thing that possibly could be opened if they dismiss it. I mean, it's not likely, but there's things here that I see what I've witnessed in other court cases that I've watched and witnessed what has happened in other court cases when they dismissed it, let time go by, 6 to 8 months, a year, up to 3 years, and then they start going after the other individuals again. And there's no criminal charges filed in this whatsoever. This man was murdered. Cold-blooded murder. Yes, they have assassination in it, but they unlawful death. And that's why I say, read the Black Law Dictionary, read Bovier's, read the structure that these men and women go by. The other point is go into the courts, ask them to get a certified copy of the statement of the court itself. You got it for record. That you should be asking these public employees to certify these issues. That is one of the most valuable education that I have received, and that's the most valuable education I'm trying to get you to comprehend. It's like an example, as everybody says, well, we all know we have a right to travel, and you go to court and you fight it, but when you don't have a certified copy from a senator, a House of Representatives, the state attorney general, the district attorney, that gives you the right. See, this is the point that what I've been studying and learning is comprehending these points that gives you rights. We know we have the rights, But when it comes down to it, as the system looks at it, are you lawful? Are you a legal citizen, national, or person? Person is an inanimate object. Look up the dictionary word of a person, too. It even tells you that in the dictionary. And when they're suing, these individuals that they're not suing. They're suing, like Kate Brown in her capacity. They're not suing her as individual woman when it comes down to it, liable for her actions and decisions. They've got these things stating that she's not doing her job, her contract, or they don't even have her oath of office in, which I know that some of these people actually have because I've sent their oath of office. I have Kate Brown's oath of office. It's on the New.Oregon Tracker New.Oregon Tracker website, her oath of office signed. And, that's what I suggest to people. Learn to read what this state is, the state. This state is the soil that you're standing on. The state is there above you, the land above you, the river above your head. They work in fiction, and that's what our court system, that's what I suggest to people. Read the British Auxiliary, the Register, the King and Queen of England, called the Bar. Is when the American Bar Association was formed August 21, 1878. And it used to say on their front page, they've been changing that because I've been passing that around, and it's been getting passed around a lot, I guess. But read the bar. It says they're British accreditation to the King and Queen of England. You got all these attorneys say, I never signed this. Attorneys are like cops. They're liars. Learn to read the Black Law Dictionary in Bouvier. Attorneys and lawyers are liars. It says it right in the Black Law in the Bouvier Dictionary. This is the stuff when it comes down to it. Either you're going to be in the British court system, Article 1, maritime court system, as some also say, too, but either you're going to be in an Article 3 court system, but you have to file. Everything on this is capitalized. That's the corporation system. It's not an Article 3. It's knowing how to present your court case. That's why it's so important to read the stuff that is out there. And I notice that they keep bringing up misconduct of these employees, but there's nothing stating in that what their misconduct is. What is a misconduct? How do you know that there is a misconduct? Because nothing's filed under misconduct. Misconduct is an open-termed word in this structure that can be interpreted any way it wants. Maybe their misconduct was walking down the street, and they stepped on the grass where it says, no, don't step on the grass sign. So these are things to think about or to bring to people's opinions and thoughts. Because once you have these things that are brought to your attention, and to look at how you're doing this, because you want to present your court case, it doesn't matter if it's a traffic case or whatever, you want to present it so you're not in court. You don't want to go in their game park, because you go in their playing field, they run the playing field. They know the game. They live the game. That's their game park, and they know it. And trying to get people to comprehend the separation is very difficult at times with people. You try to get people to see what's going on in these facts, and you try to explain things to them, and people don't want to get what the truth of it is. They still enter hearsay evidence, and hearsay evidence is admissible in court. That's like the public defender. Is it admissible in court? A judge and attorney cannot issue affidavits in court. The only one who could issue affidavits in court are the injured man or woman or on behalf of the child. And that is the living, breathing bloodline of the family or somebody indirectly to the child. And these are the things that people need to start paying attention to what's going on in these circumstances. I mean, I see a lot of loopholes. I've been going through this case several times. I posted it up on our sites, New.Oregon Trackers, United States for America Republic, Elected and Public Servants Oversights. New Oregon Trackers is on New Oregon Trackers as well. And so I'm making sure I'm posting it on other sites on the court case, so this way people can actually read this court case. I'm asking people to read the court case and respond to it. Let these men and women know what you think of it, about your education, your knowledge of court cases. Because there's a lot of us out there who have written court cases, and we know this stuff of what court cases are. We know, and we've read a lot of court cases. We know a lot about the system itself and how it works. But a lot of people don't know. I mean, the other point is, in the Constitution, church and state is supposed to be separate. And that's not even indicated in this. So that's another one that when you're going into their system and you're using their structure. See, I always advocate that way. They wrote it. We, the lawful bloodline American, quote the organic Constitution. So we're organically quoting the original Constitution, reading the court cases, reading administrative rule, reading congressional records, and we're serving them back with their writings, their circumstances. So you use their words against them, back to them, their own words. When you start using their words back to them, they can't run and hide. And this is the point that a lot of people don't get it. You know, it's like when people don't get, like I've been passing out the coffee bean case. You know, a coffee bean is the same value as $1. That was in the Montgomery Ward case. And it's knowing how these things are, but you have to put together your affidavit for the court record correctly. When you write your court case, it has to be followed up by an affidavit in Mandarin explaining what's in the court record, explaining what you're doing. And that's the one thing that I don't see this in this case. I'm not being negative. I'm just being observant of what I'm looking at. I don't see it in this case. I see a lot of things missing that could be added to this case, but I don't know if they left an open door. It doesn't look like they wrote that they could change the case or add to the case. Yeah, and that's the one thing when I do my own personal records and stuff, I always put in that I could always alter or add something to what's going on. That is the whole point of this stuff, to make sure that you can add what's going on. You can say what's going on in your court case because this is your case, not their case. This is what you have to defend yourself. And see, when you do class action court cases, it can be thrown out on one technicality. And so that means everyone loses. This is not, I'm trying to not nitpick, I'm just trying to expose. I've been trying to expose this to people for some time in this manner. I see where they're asking for some relief, but they're not outlining the actual relief in the structure. It's like, we're pleading for this. We're asking for permission from somebody to plead for this, and they're not inserting their rights to this, and they're not quoting their own laws of criminal activities that they are entitled. So you hear this, and people say, well, you're not entitled to this. You're not entitled to that. Well, you have to file your entitlement. You have to nail and write your entitlement out by their words in their court cases, in your court cases. So you want to learn how to present it. You want to go get the evidence of their court, like I mentioned a few minutes back. You want to get their go to the court, ask them for the court mission statement. Get it notarized by the clerk of the court. Get it notarized and certified. Then once you got it certified, now you got evidence of their court the way it was supposed to work. Then what are they going to do? Tell you that's not their court? You didn't get it from them? That's the same thing as the rights to travel. I mean, I'm finishing getting letters off to the Oregon State House and Senate asking them, and this is the one thing I'll be having templates up that I'm doing, and I suggest everybody else do it. Ask your state representative for the definition if the state owns your child or if you own your child. See, it's ownership of property, and even the bloodline. Even the bloodline means it. See, that is the one thing that people have to realize, that, your ownership of your bloodline matters, means a lot. It's not just something that goes off on a shadow where you don't know what it is. And that's where people don't get this. They want to go argue things that they don't know what they're arguing. We all been there. I've been there. I'm not denying that. I've been through enough bumpy roads myself. But the whole point of this is not keep going through the bumpy roads. Is so we're learning how to go in and walk out as winners. Going in, and sometimes we don't have to go to court if we write the presentment and the affidavit and the evidence in the court case before we get there. We might not even go to court because of that, because of the evidence laid out. That's the point, that you have to comprehend how this works. I'm comprehending it. I'm learning it. I'm bringing it down to the structure. And that's the point, that everybody needs to learn this structure, needs to comprehend how it works. Because once you comprehend how it works, then this way we know that you're going to be successful. You know you're going to be successful. Because when I'm going through this court case, I go through this, and it's interesting to me by the way I see the way it's presented. Oh, come on, computer, I'm trying to bring it back up. And like I said, I do have it posted around. I did send it to several people so that way they could go through it, because I think it's something that needs to be gone through. I think it needs to be studied by people, because I don't see the reference of the criminal activity. I've mentioned to a lot of people, when you do this, you have to put the crime in it, what they did. You have to put the public employees' job descriptions of their own job descriptions in what they're supposed to do. Because if their job description is not in your structure, how do they know what you're talking about? Everybody wants to do the famous word called assume. So, and what we're trying to do in our education for ourselves and others is to eliminate that word assume, that we're not assuming when we go in there. That's the one thing we don't want to have it classified as assume. So it is one of those things that when you see when the way these things are written with the department, they don't even have the department link, the foundation of the department, to prove it's a corporation. They refer to it, but there's no evidence to prove it. I mean, this thing is opened. And like I said, with the Bureau of Land Management, they've even got the videos up there saying they have no lawful or legal authority. And if you look at the refuge that everybody wants to refer to, go on the internet. It even tells you the history of the refuge. The Indians have native rights to hunt and fish on it, still there today. The refuge was never really the federal government. In 2006, the federal government re-signed that back over to the state of Oregon. That's Dennis Richardson, the Secretary of State for it. I posted that all around. I even sent it to a lot of people. So that way they had the actual evidence stating it, so it couldn't be a conflict of interest. And I don't see any charges brought up realistically against some of these men and women. They allude to it, but there's no actual charges. They allude to some of their actions, but it doesn't clarify the actions compared with their statement of facts. And it's not even really a statement. It's really written like a book in a sense, or storytelling. When I first read it, it came across to me as a storytelling issue. Not only that, but other people that have thought about the same thing, the way it comes across. This was written in people's thoughts and opinions, and mine. It was written in a political structure, so that way they could throw crumbs at the issue and get them to go fade away, instead of having things resolved. So this way, this falls back in the back archives. And this way, eventually, seeing that it becomes a faded structure in the public eye, they can do it again. That is the one thing that we don't want this stuff to be repeated in history. Excuse me, I was talking to a former Supreme Court judge back in 2000 at the Oregon State Capitol, and I'm bringing up some of this type of stuff. And as I said before on the education shows, I asked him, let's say, you're bringing in $8 billion and you're paying out $1 billion. And he goes, well, Ed, we're making $7 billion. What would you do? It's only business. And that's the one thing when you hear a judge or attorney say it's only business, that's what they're telling you. We have the right to screw you. It's only business. You do business yourself. If you screw a customer, it's only business, you say. So that's the one thing. And the thing is, they don't have what they call victim or injured party, not parties. We're not having a party. It's injured parties. Injured victims. To me, in my opinion, I'm not trying to harp on the people because they're learning, they're dealing with stuff. They've had traumatic experiences over this, and I know how it goes. Back in 1988, I lost my brother-in-law by an accidental shooting or murder, and that's when the Court of Oregon decided, we're going to go to Measure 11 and screw the jury trials. That was on the J. Smith murder trial in Portland, Oregon. The kid that was thrown in the back of a garage, buried underneath crap in a garage, was left in the garage for a week until the kid who shot him broke down in front of the principal and told him where my brother-in-law's body was. So I've been through some of this myself. So this is where I can speak on these things. I can speak how the court works. When they took away the rights for the judge, for the grand jury or jury to handle it, and went to 6-man jury instead of 12-man jury. That's what I'm saying. You have to, when you write your instruments, you have to specify. You cannot assume. We know what assuming means. And so in the definition of color of law, put the actual code of color of law in it or the definition. Because when people read this, a lot of people, when they read this, they don't know a lot of this stuff. You want to refer it, and then you want to make sure when you're doing this that there's no conflict of interest. And I see they did even put in Oregon Revised Statute of the employees, their job descriptions in it. I put that all over our Facebook walls and stuff for Oregon State employees and the structure of their job descriptions. And when they cash a check, they're liable by the Constitution, the organic. But you'll find out that a lot of these judges and these court-appointed attorneys and everybody, they are supposed to go by the organic Constitution, but they go by the Constitution of the state corporation, not this state of the real Constitution of the state of Oregon, whatever, Montana, whatever state you are in, Florida, Hawaii, whatever. They don't go by the original Constitution. Remember, they changed administrative rules. Like in 2000, the state of Oregon, Democrats changed the Constitution in Oregon to say the attorneys own all the land in the state of Oregon. The Democratic Party of the attorneys own all the land in Oregon. It's true. They changed it. Read it. I put it up. I put it out. I put it in my instruments. I've even filed and sent to the House and sent it when I'm doing those type of writings on those type of cases for myself, and suggest that when I put it out for anything else when people want to use things. That's up to them. They're adults. They're responsible for their own actions. And that's what we want to encourage is responsibility. Children should be taught the truth of these things. Now, I don't care if they're 5, 10 years old. They need to be taught. They can learn at 5 and 10. You'll be amazed that a 6 or 7-year-old kid learns faster than most adults. They comprehend it faster than most adults. And I love this. The defendants are suing under fictitious names. Or sued under fictitious names. Okay, we know the corporations are fictitious, but the men and women have real names that they're claiming to, unless they're claiming it under the de facto, but that has to be directly listed, separating them being a living man or woman compared to the corporation. See, it's explaining some of this stuff in the way you put your instruments together. That's why I do recommend, and we do have it on the new.org and trackers, read how to file federal criminal complaints by the federal courts. It actually walks you through how to do it, not the corporation standing, but how to do it as a living man or woman. Knowing how to challenge jurisdiction on these matters. That's the one thing that I don't see, the jurisdiction of the past was not even brought to be challenged in this. That should have been challenged. And the other point is liability, limited liability. That's the one thing you want to put in your cases, but you want to know that it goes by, the tax ID number of the corporation. That's one thing that you could always put in your instruments and do that. You always want to put in the DUN codes. And Emma, look up Emma. You'll be amazed what you read by Emma, the state administration of the cities and counties. It's amazing when when people write these things up. There's so much left out, and it's not explained. The way I look at this presentation is not explained very well when it really comes down to it. That is what I see. I don't see it explained well. It doesn't say, threatened, and, it's like it's not specifying. The man was murdered. He was not unlawfully death. Unlawful death is a homicide. Look it up. I even got a YouTube video, Ed Johnston, on YouTube with the so-called public pretender they shoved down my throat in Lincoln County. He even admits on the phone when they try to murder me, and he goes, well, Ed, that's called a homicide. That's legal. That's legal. It's on the YouTube video. That, this is the one thing, and we have it in Lincoln County where we got the judges even admitting they don't have oath on YouTube videos. They say don't need an oath. They can do anything they want. We've got this on videos where they're doing this stuff. And so it is learning how to file the correct instruments. And that's what fears them, because they know most people don't know how to file the correct instruments, so that way they know how they're able to get away with it. That's how they do get away with this. And see, the other thing, when I see these things in cases where they bring up unprofessional conduct, okay, how come that's not filed in the Professional Conduct Board? How come that's not filed I'll come up to that in a minute. I'll think about that. But unofficial conduct, what does that mean? There's no explanation explaining what unofficial conduct is. Unprofessional conduct, there's no explanation explaining it. And that's the one thing. And how come these men and women, when you go through this, are not filing an affidavit with the ethic committees? Because in the state of Oregon in 1972, when the Ethics Committee was put in place, it was to strip and put these public servants in jail or strip them of their credentials. In 2000, we had Don Dennison, police chief in Toledo, Oregon. He was charged with 23 charges. He was convicted of 21 out of 23. He was stripped of all of his credentials. Lost everything, including his retirement. And you can type Don Dennison, Toledo, Oregon, he'll come up. And I have that on our website, I believe, and I've posted that around. So I've been through this stuff myself. And this is where it frustrates me when you try to give people knowledge and they don't want to go by the knowledge, they don't research it. A lot of people, I've had people say, Ed, that doesn't make sense. That can't be. They wouldn't do that to us that way. Well, let me tell you, your schools are doing it to you very well. Look what it's doing to your kids. Your kids are not even properly educated today. They're so dumbed down in school, it's pathetic. They really are. The sad thing in California now, they're trying to say homeschool is a crime. It's child abuse if you homeschool your kid in California. They're trying to force you into making sure that you are corporately indoctrinized. They are making sure that you don't have rights. And that's the whole point. They are making sure that you don't have rights because you don't know your rights. And it is so frustrating when you see a lot of these cases, and I get people all the time that I look at things and I send them back and they try to say, well, when you quote one thing, when you quote in your instruments, if they destroy documents, quote the law that says they destroy documents in it. Quote your, when you do a FOIA request for those documents, quote the FOIA request date and information in your instrument. Because when you don't quote that stuff and you read it, what the average man or woman, professional, looks at that and they look at that and they go, well, it says it, but where's the evidence? Where's the reference point? How do I know that means what it really says? There's no reference points. There's no structure to go back to it, to bring it to it. Because we know BLM has no authority, because BLM Foundation, when they were first founded, and still today by administrative rules, is to do land grants and register land, allodial titles. That's it. Their policing power came from President Clinton. And that was even questioned when that was done, and that was done administratively. Because these men and women were tired of going out for people camping out in the woods, and they would come up on a campsite, and people bring guns out and tell them to leave, and they go, whoa, wait a minute, we're supposed to have this right to see what you're doing on public land. Technically, no, they don't. No injured party, actual no property damage. And I'm not talking about riding dirt bikes and making mud puddles and that stuff. It's our land. It's not their land. And that's the one thing that we've got to clarify this with our public servants. You see, when people write in their stuff, they write policy violations. Whose policy violations? What policy violations? It's not specified on what policy violations, and there's no link to a policy violation at all. But it's so open that it doesn't make sense, because if you're going to quote something or civil right, and I have the civil rights page on new.org and trackers, I have numerous court cases up there and administrative rules on civil rights that you can quote. Policy violations. Whose policy violations? What policy violations? Excessive use of force of who? What, why, and how? What excessive use of force? Excessive use of force also could be cussing. And that's been proven in court cases too. So it's like when you're writing this stuff up, learn what you're putting in, and always make sure you have affidavits to back it up. And with your affidavits, you always want to make sure you have the evidence in the affidavit or memorandum to back it up. See, without that, if it's not there, and if it's not in the initial paperwork, it leaves it open. Because, I've read a lot of court cases over the years. I've been involved in a lot of court cases, including the Pamela and Will Gaston case, won $500 million lawsuit against the state of Oregon DHS for making a pornographic movie of a 5-year-old child. I was involved in that case from the beginning to the end. Putting children on psychological medication so they can mentally control them, and then teach them that never happened to them. So long as they're on the psychological medication, they can brainwash them. Simple. And false imprisonment or false imprisonment. That's called kidnapping and held for ransom. The other point is like I think I brought up, if you are put in jail illegally, kidnapped and held for ransom, under Title 7, 136, Section D. That's animal abuse. You're an animal. It says it right there by their administrative rules. So by their administrative rules, they already got it in it, so you're using their rules, their structure, coming back to them. You know, fabrication of evidence. What fabrication of evidence? How come it's not explained? That's the other point, that, you know, that some of this stuff, when you've been in pre-court cases stuff, it's been on record, but you have to reference it back to the record. Because if you don't reference it back to the record, it leaves it open. You know, and the one thing, like I say, and I do this with my stuff. I've even put up the way I look at it as a blessing by the Great Spirit. All of a sudden, some of the House and Senate hearings that I testified over the last few years have showed up on the internet. And I've got public hearings where I'm telling off the Judicial Committee of the Oregon State House and Senate how the courts are a fraud, how attorneys are fictional material of the courts in it, and it's right on video. And the chair is, you know, hammering down, going, "Come on, Ed, that's enough. Stop it, stop it, stop it." And I keep talking right over them. And you're not going to gavel me out. This is a public hearing, guy. I have a right to say what I'm saying here. We own you. You don't. You work for us. We don't work for you. And that is the point, that people have got to start comprehending this. When they call them representatives, and I always suggest this, call your representative after you send him a certified registered mail, and if you get a traffic ticket, ask him to represent you in court. Hey, he's your representative. They're claiming that you're a fiction by your birth certificate bond, so ask him to represent you in court. Send him certified mail. And if he don't show up, make sure the court knows that they have to go after your representative because he was your court counsel and he refused to do his job to represent you because that's his job as a state senator and representative. Like I say, read these administrative rules that they have, even for themselves. And I post these things up all the time. I email them to people all day long. I'm on the computer an average of 10 to 15 hours a day, sending information to people, proving this stuff, making sure they get it. So when they have this stuff, when they do their court cases, that they have this information. And also, too, when you're filing in a court, find out what court you're going into, Article 1 or an Article 3. Article 1, Corporation, Maritime or Admiralty Court, or an Article 3, a Constitution Court. Constitutional really doesn't exist. It's Constitution. It's clarifying the words and the meaning that most people don't clarify. But these men and women, when you go to these Black Robe Priest courts, these religious courts, technically, is what they really are. When you go to these courts, they're going to nail you on this stuff. And everybody wonders why this didn't happen. And then when you use the word citizen, national person, everybody goes, well, citizen, it goes back to the original structure. Look at what the forefathers said of native versus citizen. It's even in the original filings that they wrote. I'm not a citizen. I'm not a national. I'm not a person. I'm just a living, breathing man. I'm a bloodline to this country. And people say, well, Ed, what do you do when you go to court? When they ask your name, don't you answer and respond to that? Hey, I'm here at special parents. I'm a living man. Well, are you so-and-so? I can't answer that because that's a corporate name. Well, we're going to put a warrant out for him. Okay, here's the birth certificate. And I've actually brought my birth certificate in and turned it in to court. And they tell me to leave immediately. So, I mean, I've been through this. I've even got videotapes on YouTube with me doing this, telling judges off on YouTube videos. When they tried to put me in jail saying I broke probation violation, when they had kidnapped me and held me for hostage for videotaping a cop serving an illegal and unlawful warrant. Warrants have to be signed by a grand jury. That's law. Corporations can sign warrants, but that's by administrators. And judges are administrators to the court system. So it is comprehending how these things work. And see, the one thing is, when you're writing this, specialize or clarify when you write the stuff of corporation and non-corporation. So it's all based on 1963 UCC law. Type it, you'll go on. We have it on our sites, and I bring this up in talk shows too. 1963, they filed a United States, or what is that, Uniform Commercial Code. That became the law of the land, primarily, Uniform Commercial Code. Everything's based on that, including taxes. That's like people, you can travel on the highways and you don't have to pay road tax if you know that. I'm talking toll booths and all that stuff, is knowing how to talk. Have the evidence and present it. Been there, done it myself. Eventually we'll get some of that stuff up on that too with toll bridges. I haven't got that far yet, but we're working on it. Because there's only a couple of us doing this stuff, trying to get everything up and done. But when the thing is that when you're going after a public servant, you want to file two separate structures. One is the corporate structure, and one is the man or the woman of the employment of the public servant structure, and we have those administrative rules and laws, and you want to sue them in their private and personal capacity. Oh, I said personal, inanimate object. Oh, private capacity. See, it is knowing what it is of how these things work, comprehending, and outline the definition of the government agency that you're quoting. Go in and get their administrative rules and ask them to certify it. Their administrative rules, and it'll be different than a lot of times that when they get pulled over or cited or something like that, it'll be totally different. You could always ask when you get pulled over by a public servant, call the cop, ask him for his police handbook. By law, they have to give it to you. If you don't, oh my God, he's in trouble. And they know that. Sometimes they get violent over that too. Been there. Had guns pointed in my face over it. But and then they get all upset and they get frustrated, and then you ask for the commander, and next thing you know, everybody leaves. So these are things that you have to quote. And when you're quoting misleading information, what information was misleading? What structure was deleted? What structure was not brought into court? Because they can say, we can strike that from the record. Okay, but you still it might be stricken for the record of one court case, but bring it into another. Let them striking it for the other. Then they're going to have to justify that. It's going into this stuff so that way you go after them with as much ammunition that you have, that they have to question, their own circumstances of stance if they get busted in human trafficking. I don't see anything in this court case of human trafficking. Every member was involved in human trafficking in this for personal financial gain of the corporation. Everybody involved in this case was human trafficking. The cops, the governor, everybody. And I know I posted that all around places. I sent people the administrative rules on it, the laws on human trafficking. Not only the week before Christmas, Donald Trump did an administrative rule on human trafficking, and if you prove that elected and public servant was involved in human trafficking, they lose all their assets and they go to jail most likely too. That is the point. And when you go to court on these issues, it's like, what was the charge? How can you be convicted of for charges that you do on your own land? See, and that's the one point. Research that. When they try to bring this in, research it. Go challenge them. See, you have to challenge these men and women because they come up with rules and administrative structure for their personal gain. And remember, when they're using the court system, that's theft of public property. That's theft of public assets. Because the public is paying for them, that we're, to the best of our knowledge. Fair to say. So if we're paying these people to do these jobs, and they're not doing it correctly, that's misuse of public funds. That's theft of public property. And there are laws that even state that, and the laws that even state when a public servant steals public property, public laws, and it even has jail terms with that. But it's proving this stuff, but when you put your affidavits together, see, I mean, you know, when I look at some of these court cases I've been reading, some of these things don't have affidavits following them. They're open like a storybook. And trust me, I've been there. I've written stuff. I posted all over the point, and I've had people say, God, Ed, you know, you're sitting there doing a complaint and whining and crying about what? It's a storybook. I mean, I've been there. I've written the stuff, and then I start going, oh, Jesus. I'm starting to sort of pick the pieces of the puzzle up here, going, I missed this. I missed that. I got to pay more attention. And so when it comes down to the word, like I said, always look at what citizenship is under the 14th Amendment. I have paperwork from Congress that says it was passed and it wasn't passed. So what is the Congress can't even answer that, but I've got court cases that says that in 1884 separated lawful and legal, and I put that in our letter that we put out for our talk show every week. So, I mean, I have that information in our talk show. I mean, I've had people that says, Ed, I don't have time to read everything you post in for your talk show. Well, if you actually read it, you'll find out you don't have to pay taxes. The laws are there. The administrative rules are there. I do that for a purpose. I even put the structure in for police officers in that structure, because you can even go to the internet and type it in, but I provide it with all the stuff we've got on the structure. A new.org tracker or Facebook site, and you can type in that on the internet, it comes up. But police are not there to protect you. Police are revenue collectors for the city, county, and state. That's their job. That's what their job is today. But technically, if you go back in the real structure of their employment, their job, by their own administrative rules too, is to arrest code breakers. Code breakers are elected and public servants, registered voters, registered church members, and illegals. Not native. And it says this stuff in their administrative rules. It says it in the paperwork. And I pass this stuff out, and I've had people go, well, Ed, I can comprehend or I understand what I read. Of course, I don't stand underneath nobody, neither will I attempt that deal, because I don't bow and I sure don't kneel. And so the one thing is when that happens, is knowing what the administrative rules are. Administrative rules are the corporation. I can go into Walmart or Sears or some supermarket. Their administrative rules for their employees and their corporation don't apply to me. That's one of the best ways to explain it. I go into a business, their corporation rules don't apply to me. You know, I'm called a purchaser. I don't like the word customer, because you got elected and public servants saying this even in courts when you go to the court, and they call you a customer. I'm not a customer of the court. I'm an employer of that court. They're an employee by the structure of the law. Of the law. And remember, law even means statute, codes, and administrative rules. Constitution is separate. And I always write in my stuff, Constitution, law, and that's the point. Constitutional law versus statute, codes, and administrative laws. The one thing is to pay attention to how your courts and administrative court structure actually works. So, I mean, I got a poster that I post all around, too, that even says an officer is bringing in a guy with handcuffs to the judge, and the judge is going to the plaintiff that, remember, me and your pastor are one and the same. And they are. And most pastors work with the police departments around. Trust me, I've witnessed that even around me in my own community, where somebody tells the pastor somebody did, and they were trying to make amends before the amends was made. The pastor tells the cop, next thing you know, they're arrested. And by law, they're not even given a chance by law to make amends. And by law, you have a right to make amends before you even end up in a court system. But they're not going to tell you that point. That's why if you end up harming somebody or property damage, you write an amends statement up and make an affidavit, and you make sure you give it to the injured party. and you make sure that it's done in a responsible manner. Then that way, the court can't get involved. That's the court administrative rules. So as I bring this stuff up, it's so important to read this stuff. You can take a horse to water, but you can't make them drink. You can give that people education, and if they don't care and they're too busy with their video games or program TV or the sport games and stuff, they don't take care of their responsibility. And Malheur National, that Malheur was given over back to the state of Oregon Wildlife Refuge, in 2006. I was there when that was happening, when I was up there at the Capitol. And I sent out that paperwork to people. I made sure people had that evidence. And I tell them, refer back to Dennis Richardson, Secretary of State on that. And then when you go through some of these things, like even Oregon Blue Book, how they're changing things in it. That's why I always believe in keeping the old records or old newspapers and take the old newspapers to the new newspapers and see how they're rewriting things. And see, the other thing is that public land is the city, the county, state is public land. I have even administrative rules that, banks can't own property, and that's even by the Banking Act laws. Cities, counties, and states cannot own land. They can't sell land, technically, what they're doing, and I'm working on something on that one, because we the people own the land. It's public land. They're on public land. They have privilege of employment services. And if you actually read the 1871 Vatican contract that the Civil War turned out with us after the Civil War, it brings these points to life. That's what I said. They wrote it, quote it. But the other point is that you want to go into these offices and ask for their information to be certified. Once you get this information certified, then when they try to come after you, it's like driver's license. I'm working on that. I've got a few responses back, and they've been positive, and I'm working on getting some other things certified now. But when you got it certified by them and their own administrative rules or senator or Department of Justice, what are they going to do? Go against their own certification? See, I'm still learning. I don't have a problem admitting to my downfalls of what I screwed up in, because life is a learning experience. But it depends if you want to learn positively or negatively. And sometimes when you screw up, and I've done that, you just got to laugh at it. Or say the heck with it, go have a couple shots and just deal with it later. And then when you wake up, when you come back to a new comprehension of understanding. I'm not saying to go get looped out of your brain, but I'm just saying get out there and change your thought pattern. Think about things a little differently. Work on projects that you're doing the research and reading their administrative rules. It's like I have another friend of mine that always tells me, read the court administrative rules, how the court functions. And in that way, because I don't believe in actually going by the court function. I believe in going by what I'm doing, but I want to know ahead of time what the court might do. I want to know ahead of time what a judge might think of how he's going to handle something. And by reading this stuff, you get to comprehend what he might think or what she might think or what the clerk might do or what somebody else in that position would do. It's thinking about how somebody else thinks. It's putting these thoughts together of how these men and women are going to do things. So it's thinking ahead. That's one thing that most people don't think. Of course, what they say is we're not trained or educated in this. Okay, but see, the thing is, who cares if we're not trained and educated in it? You have a brain. Train your mind. I know how difficult it is when we've been so brain altered to the ownership or the structure that we've been screwed up in the way we were wrongfully educated. So it's getting your mind out of that, I used to sit there and do mind games, you know, when I'm driving down the road. Look at this, look at that, you know. We used to play, what was that one game? I see, you see, you know. And, you know, those are good mind exercise games to even play with the kids when you're traveling. Most families do it. And then when they get to a certain age, they forget what they done and how they did it. And see, when you have property damage or property loss, you clarify and state it. You have to state these things. You can't leave it open for interpretation, because law is open for interpretation. Judges are open for interpretation. It's like I always suggest to people that I have learned the hard way, is that when I turn in an instrument to court, you put it on the front and back of each page. 1-1, 2-2, front and back. 3-3, front and back. So when a judge flips the paper, he can't say I didn't see that. And I've witnessed that. Not only in my own court case, I've seen that in others. And you're like, well, it's on this. And he goes, I don't see it. And you're like, what? But on the flip and front and back. And I was suggested that by a judge that told me that at the Oregon State Capitol, which I thought was pretty interesting, learning that from this one judge that said that. And so it is paying attention to the little quirks, little things that happen, the little structures around you that open up these things for you to look at the way things are brought to the attention. Because if you're writing, the one thing with a court case, you always want to have the evidence, at least a brief summary and a link to it with your deal, so that way you got the other main evidence turned into it. Because what gets to me about it, this ain't like it used to be in the old days, 40 years ago. You could write up a case, something like this. Then when you get to court in front of a grand jury, you get to argue about it, or you do a negotiation before you get in front of a jury. Today it's administrative courts in Article 1. This ain't an Article 3 court, it's Article 1. So you don't get that opportunity. And I always love this when people put it in constitutional, and I've even argued that myself, and I find out, well, what does constitutional mean? There is no word constitutional in the Constitution. What the original forefathers wrote is a lot different than what we're being taught today, and a lot of this stuff is taught by attorneys, lawyers, judges that are bringing it out to convince us to go along with their language so they can keep us controlled in their ballpark. Because you have to look at it this way. You're going into their baseball field, their game. So you have to learn when you go in their game of how their game plays. And that's what you want to do. Comprehend their game. So there's a lot of stuff that I read court cases and I see things that are left open. And when you read a court case and there's no evidence directly outlined in it, there's no explanation of elected and public service job description. I don't even see, what is that, Title V, Section 3331 or 3333 that says that they have to comply. I don't see anything that says it's a Republican form of government that they have to do. Republican form of government, not Republica. And I do Republic or America in my deal, or Republic America, but it's a Republican American government. And I misquote things, but then again, I have to come back and say, oh, Ed, you missed this. And then sometimes I have somebody go, hey, Ed, did you see this? And I'm going, yeah, here's the way it is, and I missed it. And they're going, aha. It's like, you got to laugh at these things. And see, how can you trespass on public land that we, the people, own? And believe me, I know people who have been arrested on public land. I've been threatened on public land. I got a videotape with me at the City Council Toledo meeting where I was threatened by a police officer, and I just went and said, okay, I'll just leave. And I nailed the city, and I sent a letter, and then the cop resigned after I sent the letter. Nobody knew where he went to. He went to another department, more than likely. But he didn't want to be charged. So he left. These things do happen. When you write certain things and all of a sudden that employee's gone, you know that more likely he went to another area, so that way, they protect themselves. And I've actually gone after public employees that, when I nailed them such a fashion, they were sent to another agency in the middle of nowhere in the Ice Age, basically. Alaska, Colorado in the middle of winter, Wyoming in the middle of winter. So they punish them that way when they screw up. So that way, they still keep their benefits and stuff. They're still employed. But that's the way they punish people in their system, by sending them to another area that is not desirable, that nobody else wants to be at. And so the one thing that I always look at court cases when people are saying false and misleading information. What's false? What's misleading? Some of this stuff I'm repeating again, but I want to get it through people's head. If you're going to make a claim of false and misleading, put a statement, or it's in this paperwork with the memorandum, or it's in this evidence package, or it's in this affidavit. Because I don't see anything of affidavits written for any of the injured men and women. And attorneys and lawyers cannot write affidavits even by their own administrative rules. And we have that up on new.org and trackers. And I talk about it all the time, and I've passed that information, the actual administrative rules on that, to people all the time. And remember, a district attorneys are hearsay witnesses. Technically, they can't be in court, because the only ones that can be in court are the injured party and the man or woman who's injured. And so you could have representation of counsel, but you have to clarify who's representing the counsel. See, counsel is one of those things, too, you can bring in. And they don't like it when you bring somebody from the outside instead of their own structure that they try to shove down your throat. They're public attorneys. And believe me, I've fired public attorneys. I won't have a public attorney, because the public attorney don't work for me, because he gets paid by the court system. Oh yeah, you're obligated to get a public pretender. And the courts pay him, so he's going to work for the court, because he knows he gets another job the next day, and if he goes against that, he's unemployable. It really does happen that way. So in these cases, when you're putting these things together, go after them the best you can. Go after. The one thing is always, and I suggest, because I had a wonderful suggestion from a gentleman that said, hey, get it certified, prove it, take the certification in. Isn't this the way your court works? Oh, shit. It's things, little things that people oversee that means a lot more than people realize. Little things that we miss that mean a lot more than we realize until we comprehend the information. And see, the other point is that when they issue no arrest warrants and stuff, even arrest warrants have to be done by a grand jury. A municipality administrative judge cannot issue arrest warrants. You can issue them to elected and public servants, registered church members, registered voters, all immigration. But that's why you need to file your rights, to know that you're lawful versus legal. And I mean, knowing that your Constitution rights are intact. See, that is the point of knowing that your rights are intact. And if you don't know that your rights are intact, how do you know what's going on? See, you have to know these differences. And if you don't know these differences, how do you expect a judge, a black-robed minister, when you walk into court, to know what you're thinking? Did you put it in writing? That's the one thing when you do write letters to public servants and elected and public servants, put it in writing. It's your responsibility, not theirs. See, they don't work for you. And as soon as you start figuring that one out, you've got it made. And so when you read court cases, look at these things. Open the mind. When you see stuff missing, when somebody's trying to explain something, put it in the explanation. Put a memorandum into it. See the court evidence on the other page. Put something in that you have a reference to. Once you put the reference to these things and you put it in it, it cannot be open for interpretation. You don't want it open for interpretation. When you leave these things open for interpretation, this is how they win. Because it's like when you read court opinions. Court opinions are opinion of the judge or the attorney. And everybody knows what opinion means. It's like dirty diapers need to be changed regularly. Elected and public servants need to be rotated immediately when they do this. I don't see why there's no complaints filed with the professional board. I don't see why there's no complaints filed with the ethics committee. I don't see why there's no complaints filed with risk management. That's the one thing, it makes you wonder, are people comprehending the system itself? Are they comprehending anything about how the system works? This is the one thing that you're entitled to bring up. You are entitled to question the jurisdiction. What jurisdiction are you in? Are you in military law? Are you in Vatican court system? Are you in Article I court system? Are you in Article III court system? Question the jurisdiction. Most people don't even question the jurisdiction. It's like when I was talking to the judge up there with traffic tickets and stuff, he goes, hey, 80% of the people are going to pay the ticket. 20% will question it. Yeah, we throw 20% out, but we get 80% income. What would you do? So, you got to think the way these people think. A lot of these people think criminally, and that's the way they actually think because that's what they do. Remember, public servants, rape, rob, and pillage. If they honor their constitutional oath, the constitutional oath they're supposed to honor, we wouldn't have half the problems we've got today. But they're all about making income. And that's why when you're able to prove that they're doing human trafficking, especially like the Hammond and Bundy's case, human trafficking all the way. And that needs to be explained and executed in the stuff. But, it's bringing it into it. Knowing what, especially this is one thing I've done with the Oregon State Police. Go get a copy of their administrative rules. I didn't think about it at the time. I should have got it certified, but get their stuff certified. Go to your sheriff. Get the copy of his rules certified. Because then that way, and that's a valid point that, is when you get it certified, it's their rules, their stuff. It's not that you got a piece of paper that could be brought into court and say somebody else did it. I got it from a copy machine, and I don't know where it came from. You can't do that. See, that's the one thing that you cannot go into court and say that here's a piece of paper, and you can't say you don't know where it came from. And so that is the one thing to bring to court. What the evidence, what the circumstances of your statements. And when you do that, don't forget to get your stuff notarized. Is a good way, and I do believe in notification, and I do believe getting it 3 men and women to sign it too, witnesses. You always make sure when you do this stuff to at least try to get witnesses with the notification with a affidavit of steel. And in this way, you've got these things that help you in your case, your court case, your affidavit. Even when you go for foreclosures or stuff like this that they're doing stuff, it's like foreclosures. I always ask people, did you have a copy of the original note? Well, no, I didn't get one when I did the bank. Well, why not? And in the notes, they always have insurance on it. So if you don't pay your mortgage, the insurance covers it. It's in the contract. You pay that insurance with your monthly premium. That's to protect you and the bank. So it's very important to get this stuff notarized. It's very important to know their administrative rules, because you have to know how your public employees have written their administrative rules to conduct business. You have to know when they take your property to file property theft on them. You know, if they take your vehicle, that's grand theft auto. There's a lot of things that people miss when these things happen, and they don't get into it. And when you go and you put in, and I've done this where I put in like recordings and stuff, but this was a few years back, and now when I put in the stuff, I always put the links in it. I put the reference points into what I do. And some people tell me, you know, I mean, I put together paperwork that, you know, is about this size, 248 pages, and they say, well, the judge ain't going to read that. And I said, I don't care if the judge reads it or not. It's in there, and if he misses it, it's not my fault. It's in there. It's evidence. You know, this one they're going to go through, but like I said, this is, in my opinion, written politically. It's written sort of like a fictional book in some regards. And I've seen this before. And there's no description of these people's job descriptions. There's no descriptions of links to memorandum or affidavits. So I'm just bringing out things. I'm not trying to go after anybody to offend them, but I'm just bringing up points that this is, if you want to win in court, and you want to make sure that you're successful in these endeavors that we get forced on us by these criminals. Because, you know, I mean, I've had guns shoved in my face by cops. I've been shot at by cops before. Thank God I've missed. Or the Great Spirit. I'll use that word for those people, because I don't believe in a structure that comes from another country. But that's my right to believe that. And that's your right to believe in what you believe. But that's the point, that we're supposed to respect one another's belief instead of argue and fight on it. And then we come to a mutual understanding, like what's going on with this stuff that has happened. You know, we know that these people destroyed evidence and stuff, but what evidence did they destroy? You have to put something into the court reference for a judge to go referencing on. Because when they sit down at the table, and they, believe me, they pour everybody, the public pretender, and everybody will sit down at the table and go over things and figure out the right way or the best offer or stuff like that. They go this before it even goes to court. They make deals before it even goes to court. I don't care if it's a drunk driving. I don't care if it's driving without a ticket. These judges and cops discuss it before they get to court. And they do. And what is wrongful death? It's murder. There's injured men and women because of a murder. Wrongful death. The frog jumped across the street, got hit by a car. The frog was wrongfully dead. Now, I'm not trying to make light of it. I'm using an example of that, what they've actually used in court before. So, I mean, that's the one thing that I just want to bring some information out to the people on this stuff, because when it comes down to it, when you write your stuff, you have to include an affidavit. That's the biggest thing. You have to include an affidavit of fact to back up the statements one is claiming. Otherwise, when it's open for interpretation, anybody can interpret it anything. I don't see anything written under the corporation structure that these are, they actually have it as employees and officers and stuff, a violation of the Fifth Amendment. I don't see the structure of the Fifth Amendment when it violates directly in it. I don't see their contracts, links, or something to that point where proves that they're violating their rights. See? I mean, there's nothing to back it up through the structure. And I mean, I don't understand why Oregon State law administrative rules are not put in this, because when they violate it, they even have ORSs that say when they violate these type of things, they actually have laws in the ORS that public servants, if they do certain things, go to jail, lose their homes, lose their assets for violating their public servants' duties. Every state does, but you have to research it. You have to look for it. So anyhow, it's been about an hour and a half. I think we'll just open up the floor, see if anybody wants to speak on this. Anybody else has got some thoughts, or throw something if I missed something, or if I outspoke on something.
All participants are unmuted.
Anybody would like to chime in? Okay. I know it's a sensitive issue. So, but one thing, you know, when you read the case, and I did put this case out for people. It was sent to me. It was sent to me by the people involved, by people around the people involved too. And, you know, I mean, I told them, I said, you know, I'll read it. And, but I'm looking at the stuff is that when you put a court case together, was that somebody there or somebody leaving?
No, I'm here. I was waiting for you to stop talking.
Oh, go ahead. Speak up.
No, we were talking earlier. This is Dave about the mortgage insurance concept.
Yeah. Go ahead, Dave.
Well, I racked my brain thinking about that. I think what you were referring to is something called PMI, where they, you know, in certain loans, they require that you pay this mortgage insurance. Am I understanding you correctly?
That's in every mortgage contract, yes.
Well, my mortgage was with frickin' Wells Fargo, and I'm looking at the original on, you know, legal, not the bogus photocopies they make and put in the foreclosure. And I went to I was thinking about, you know, like the cost, essentially, of the PMI. So under number 10 is mortgage insurance.
Mm-hmm.
Then there's a couple of subheadings, if you will, A and B.
Right.
But basically it looks like boilerplate because it's all on these, you know, I would say government conspirator, you know, guys that publish this real estate crap. This is a VMP mortgage form, you know, approved by Fannie and Freddie, Florida single family. Anyways, long and short of it is that I think it's optional for them to burden you with that. Here's what it reads. Borrower shall pay the premiums required to obtain coverage substantially equivalent to the mortgage insurance previously in effect at a cost substantially equivalent to the cost to the borrower of the mortgage insurance previously in effect. Blah blah blah. I never paid for PMI. This was a loan that was PI only. I did the loan, so it was principal and interest with Wells Fargo, and they carried.
Did you ask for a breakdown?
Well, I have the whole file in front of me, so that's where I was
okay.
Kind of looking for clarification from you where to look.
Well, I don't have the contract in front of me, so I can't go that, and I'm trying to pull up a page here to bring up some things to you. But, and I believe
it's a standard 3010 form. What I'm getting at is that it sounded to me like you were saying it was like an absolute.
Yeah, they have it in it to protect them and you. That's in every contract. That's one of the bonds that basically is in every contract. Every bank contract puts the bond in, and the banks carry the bond for themselves or for you if you don't claim it.
Which is where, yeah, I'd love to go with that. You know, I'm just trying to make sure I'm understanding what. The first line is if lender required mortgage insurance as a condition of making the loan, which was not the case. So the first sentence basically, from my read on that, is verified by the second line, borrower shall pay the premiums required. to keep the mortgage insurance in effect. So are we talking about two different types of insurance, one on the, if you will, the public side that we're looking at, and then one on the private side we're not aware of?
Well, yeah, it's both sides, but like you just read, it says shall pay, and that's the point. I'm waiting for my site to come up, see what I got.
No, let me reiterate that. It says if the lender required it as a condition of making the freaking loan, quote unquote, alleged loan, purported loan, borrower shall pay if the freaking lender was requiring it. And that was one of the aspects of this loan. It did not have PMI. So I'm wondering if I'm short on that.
Well, have you ever read the Fannie Mae borrowing and the structure of the Fannie Mae PAC of the way they loan?
Within this particular loan?
No, I'm talking about the corporate structure, the way the corporate reads.
Like on the Fannie Mae site type stuff, or related to this paperwork?
On the Fannie Mae sites, because it gets in it on the structure of the Fannie Mae sites, where they put that in that and coverage of it. See, and they do that to protect themselves on it. I'm waiting for.
Well, this is a weird loan. This is the background real quick. We went to buy a new house and backed out. 6 months later, I went back to the same girl that had all the paperwork in the system, and I said, hey, I found another property, the same price, around the corner. I'm going to buy that one.
Okay.
And she's like, oh, yeah, no problem. The loan's still in the system. I'll go ahead and write it up. Well, after a half a dozen, TILAs and various screwed-up documentation, we finally signed. And upon doing so, the type of loan that it was did not require PMI. And without getting into a lot of stuff, because I know you're recording, but the bottom line is that I'd like to understand that better to know where to look if that, in other words, because it's a Fannie Freddie form doesn't mean it's a Fannie Mae guaranteed or Freddie Mac insured loan. You understand?
Well, I see your thought on that, yeah.
So essentially the mortgage itself is, in my opinion, it's a Wells Fargo home mortgage, Wells Fargo scam deal. And the way they did it is they used pretender lenders, and everybody out there that's possibly gone through this type of thing. The pretender lender, in my opinion, and I have some evidence of this, is that Wells Fargo shut down their mortgage arm here in Florida in 2004. They literally dissolved the foreign corporation registration with the, Sunbiz guys here, the Department of Corporations. So that being said, it looks like premeditatedly, then they set up a whole slew of these freaking pretender lender LLCs that down the road they could shut down and allege arm's length. Oh, no, we weren't involved with that. That was the freaking broker that screwed you over. No, that wasn't us. However, the documentation is very interesting because all of it goes right back to Eagan, Minnesota, or all of their addresses are the same.
Right.
For Wells Fargo and the freaking pretender lender. You with me?
Yeah, I'm with you. Now, did you get my information that I sent you that is in Florida State Attorney General's office right now with them in bankruptcy and the foreclosures, that the fraud that they have done, and they have $1 billion right now to be claimed by people who signed those contracts?
I didn't open that. No, I'm deleting a bunch of emails without going into detail. My computer's kind of locked up. But I will look at it later. For sure, dude. That's awesome.
Okay, yeah, because if I have to, I'll have to resend it to you because I want to make sure you get that because they have 3 major cases in Florida on bank fraud from that corporation. Not only that, selling and trading mortgages and seeing if you didn't sign for the mortgage to be signed or trade in the original contract, they can't do it.
Oh, I'm sure that they...
But you have to read the contract to know it.
No, I have everything. We talked about that earlier. What I did not receive, interestingly enough, was any sort of right of rescission when I did this, so that's a major TILA. But as I discussed with you, as opposed to fighting the fight, which is the fraud fight, which I have all of that documentation, and it's all verifiable, these cases are not winning in Florida. And I've been watching it closely for 2 years, and I have a friend of mine that's been doing it for 10 years that I introduced you to, I think. Anyways, that guy just lost and literally walked for $3,000. and I won't go into any particulars on that, but he fought the good fight for 10 years. And then he just literally what they do is they wear you down to a point of depression, suicidal tendencies, call it whatever you want. You're just you're just ready to check out as opposed to fight it anymore because they can out-resource you. And it's like the IRS. They've got years and years and years of ability to pursue you if you don't know how to, like you were talking about earlier, opt out of their voluntary system. But
right. Did you get the information I sent you by paying debt with a debt is a federal crime by their own administrative rules?
Well, and I agree with that completely. I haven't gotten up to speed on that yet.
Okay.
But obviously, they're not lending money in typical loans. However, the unique aspect of these products is that a mortgage-backed security was sold by, in this case, Goldman Sachs in conjunction with Wells Fargo Securities Corporation. So they had $1 billion up front burning a hole in their pocket that they needed to place in these mortgages.
Right.
And as the warehouse lender, they actually did have a transfer of credits, call it whatever you want, money. But they did have the funds originally sold to securities, and then those funds needed to be placed in these bogus loans. And the reason I know that the credits transferred is I saw a guy walk away with a $101,000 check. I saw his freaking check. So, whereas in a traditional loan, if you walk in and you sign for a credit card or an unsecured debt or even a car loan, those funds are created as a result of your signature, right?
Correct, including a house loan too.
But what's different, this is the nuance that I'm trying to elucidate, is that the difference here is that I could subpoena the records in a plaintiff's posture attacking this thing, and they would have to, under GAAP, provide the documentation showing where the money came from. And I already know where the money came from. It came from the freaking RIMIC. It came from the $1 billion sitting in a piggy bank that they needed to fund into these loans. So that's where you have to kind of like be flexible in your thinking and say, okay, I understand that you understand a bank cannot loan its own money. I understand you understand that there ain't no money. But by the same token, the credits, whatever you want to call them with a dollar sign, those zeros and ones, digital currencies on a screen someplace, were acquired up front by them selling these BS mortgage-backed security tranches, et cetera. And those funds actually did transfer. However, there was not a loan made, in my opinion. And I believe that's something that's, defensible position. I'm kind of off point, but you get my drift.
Yeah, but that's the point where you know that, but you never sent them the letter for them to prove that structure.
We went down a number of administrative processes.
So that you might,
know what I mean? I'm not sure what you mean by that letter. If you want to be more specific, if you're talking about a QWR or something along those lines.
You sent them a letter requesting a copy of the original loan or to produce the wet ink original loan.
Well, of course I did, and they just played dumb.
Then you have to file on that dumbness that they didn't produce.
Yeah, what I did is I requested the wet ink blue signature note
in certified mail.
Absolutely, bro. And here's what I sent you, and this, for the edification of your listeners that are in foreclosure. After spending a couple of years in various groups and trying to confer with the most learned, counsel out there that's not bar, but is actually like yourself, self-educated, understanding the law and what's lawful and legal, is we came to the conclusion that you can fight it and you can use all the losing arguments and you can stay in your home for maybe 10 years and get a couple, 3 ulcers and, fend off all of the suicidal tendencies and all that stuff that comes along with being basically beat into the ground financially. Or you can take the tact that, as you were referencing earlier, UCC under the Uniform Commercial Code, that dictates the law of the land. And if you are an issuer maker of a note under UCC 3, a negotiable instrument, that's your freaking note. The fact that they took that note and absconded with it and didn't tell you it was your note, and then did all this hanky-panky, bogus bull crap that they did with regard to the securitization and the scam, flim-flam scheme that they ran, is, neither here nor there. They took your freaking note. So when we ran the DTCC report for my wife's name, because they actually ran it under her name, because they only had her sign the note, supposedly, which I don't recall to be the case, and my note is signed by both. In other words, we got a blank copy of everything, and, we signed everything to the best of our recollection as we did their originals. But the long and short of it is that because my name was not on the note, 7,851 international investors own a piece of her assets. In this case, it's primarily the mortgage. So when you pull up that report, you can see all the international, Luxembourg, Switzerland, all these freaking institutional investors bought a piece of this asset. And
right.
So you can see who you can kind of follow the paper trail from the outside, but you really can't get behind the curtain unless, I understand, you come in as a plaintiff and sue them as we're doing a counter complaint. Because, again, we're being pushed to shove here in this foreclosure. We've been trying to, I've tried a private correspondence to the CFO to settle it. I've issued bills of exchange and actually entered it into the case. I mean, I've done everything within my ability to document the fraud and to show our good faith resolving it through issuing another piece of bogus paper or whatever. And the long and short of it is, at the end of the day, they're just like, F you, we're not even paying attention. So you have to come in as a plaintiff, and that's why we're doing the counter complaint for the note, because the 7,951 people that invested in that note, that means they took the Coke bottle and threw it on the ground and broke it into 1,000 pieces, and each one of those tranches has the same freaking value note. So
right.
The $224,000 note times 1,000 or 7,000 investors. Do you follow me?
No, yeah, I know that, but the one thing that I did send you, I believe I sent you, was Congress to Fannie Mae stop using the Florida foreclosure mills that they've been doing. It's already been through Congress, and they already issued statements and remedies on those things.
And that's all great. I just wanted to, point out a couple things. And one was that some mortgages do not require PMI, so that's not a blanket statement one can make. And the other part of that is that if you're going in on an argument in recoupment, it's just the legal argument that I want my note back, and all of the profits made, and that's where Ken Dost of Dost Fictions, and you're familiar with him and his copyright stuff and all that, yeah?
Yeah, Ken does good work. I mean, didn't he send you his template?
I'm just saying, I've used some of his stuff, I'm just saying, but where he's verifying that, they're using these patented processes to essentially, run the game. And all I was getting at was that if there are 7,000, just use simple numbers, 7,000 entities that also have a $224,000 note or a piece thereof, you're not just getting the $224,000. You're not just going for the $224,000 principal. You're going for all the investment profits and everything attached to that. Does that make sense?
That's what they try to do. Yes, that's what they try to do.
As far as I know, the only methodology that it has worked. I've got literally, maybe they'll let one out, and I don't want to say 1 out of a million, but Wolf and various, success cases, maybe 1 out of, maybe it is 1 out of a million. Realistically, how many millions of foreclosures have been and how many winners there's been. So, the foreclosure groups that I've been involved with for the last couple of years, all you hear about is, them running, and these guys have good arguments, good legal, like you're talking about. The documents are solid and such, but when it comes down to it, you have a judge whose retirement plan under Bush, Jeb sold all that stuff into these mortgages and got, I guess, $500 million or something like that when he was in office here. The bright guys, the illuminated guys, they have a system, and they've already done the job. They've already worked the system. So all we're trying to do right now, again, is to share this for the personal edification of those that may be struggling also with the concept. is understanding what Gene Keating put out, and really what he said in Securitization, a couple documents that are on Scrib, is he's saying basically, I guess the best way he put it, he just said this, I'll just read it if you're okay with that real quick. He says, we're looking for one, yeah. He goes, we are looking for once, we, the creator of the promissory note, have signed it, and others are using it. Recoupment means we want our property back, or we have the account set off. Recoupment, and that law is on the books here in Florida as well as every other state under their local UCC, recoupment and set off. He says, recoupment is a counterclaim in a civil procedure, and all of these freaking courts here are suing you civilly. That is how one does a recoupment. We did a counterclaim on the grounds that with the county, you can do a set-off. You can use the financial liability of the accounting ledger to offset the financial asset if you have the right to do that. But you have the right to do that if you are the creditor on the liability side and the bank or lending institution is the debtor on the liability side. And I'll stop there. That is called foreclosure recoupment. And again, it's on Scribd if anybody's looking for insights on that. But the long and short of it, going to the laws, like you're always quoting the law, which I appreciate that. He goes into UCC 306, and basically the claim under 306, you have a possessory and property claim against the cash proceeds under the liability side of the ledger. UCC 3306, there cannot be a holder in due course on a promissory note. And then he quotes Title 12 USC 1813 L1. When you deposit a promissory note, it becomes a cash item. It becomes the equivalent of cash because I have a cash receipt. And I talked to Walker Todd, one of the heads of the Cleveland FRB. Everybody knows that name. He has been a government witness in court cases regarding BOEs, which are bills of exchange, of course. He said that I'm correct that we are the creditor on the payable side of the ledger. The bank owes you the money. No one is bringing this up, recoupment as a defense. You waive the defense, and they go to collection on the receivables. And I'll just stop there.
Okay, and like I said, that's the one thing that I do have some of that, like I said, on New.org and Trackers, and I have this other one that, that I was trying to get you to go through to read that this guy did last May 2017 on how he stopped his illegal foreclosure. I tried to get that to you to read and comprehend the process that this guy did in Florida. And I got other friends of mine in Florida who have gone through this and stopped this stuff. And so that's what I'm saying is that when you question this stuff, you want to make sure you're asking for the notes. You want to make sure you're asking for their evidence to produce. And when they sit there and ignore it, because you're already in the court process of it, you write to the court and you say, I didn't get this request and demand.
Let me tell you what happened.
Wait a minute, let me finish. You insert your right for the judge to do his job because it has the judge's oath of circumstances of the administrative rules he has to follow. And so when you quote his administrative rules he has to follow with that, it puts him in a bind. And that's what you want to do, is put these men and women in a bind by their own circumstances. And don't forget, it went through a title company. Where's the title insurance? Because you have title insurance on that for the bank too, and yourself through a title insurance. You get it? Are you there? I guess he hung up. So, all right. Well, we'll let that one ride the way it is. So, I mean, I get where he's coming from, and, that's the point. We have this stuff.
Either I muted myself or you muted me.
Oh, okay. Well, anyhow, what I'm trying to say is that, I've got information I sent you. We've got people in Florida that have won their cases.
Good.
Let me finish. I'm trying to get this information to you, including dealing with Volume 13, Part 12 of Congressional Record, June 12, 1967. This stuff has been gone through even by Congress, and you want to use their structures that they wrote on the way it works. And once you sit there and use their ways with it, they can't argue with their circumstances that they file, that they use for themselves as well. This is how these men and women do this stuff to keep their assets when they screw up. You know, and you know the definition in Black Law Dictionary of a mortgage. You've read that, haven't you?
Death paper, I believe, or something to that effect.
Okay, yeah. And so this is the one thing that, you know, bringing this stuff through, and this is the point that when they don't respond to you, then you respond back to them saying they didn't respond, so what you said is on record, and that's what basically it comes down to. That's law. They didn't respond. They admitted to the terms. But you have to bring that back to them that they didn't respond. They agreed to the terms that you quoted to them, excuse me. So they agreed to the terms by silence.
I understand.
So that is the point that when you send them back these things, and that's where I think I sent you to, dealing with the foreclosure structure in Florida, because I noticed that it's basically not on the site anymore, not on the internet, because they already have this going through the the State Attorney General of Florida, and they have this in record under the State Attorney of Florida, and you can actually request that from the State Attorney Records of Florida, and they will send it to you. And I know other people have done that and got that information and used it in their court case.
Right, and I could share a detail with you. It might benefit the audience if, you know, anybody listens to this down the road or is on.
Get it out.
Yeah, real quick. So in Florida, you have to have an attorney sign that it's a verified complaint. My last swings were to dismiss the case based upon it was not verified, because under the laws that they changed here, they have to sign, again, under perjury. The attorney has to say that they know they have the note, because these missing note issues, these fabricated documents, etc. So, Ed, what it boiled down to is when I went before the judge on a document that's written on like freaking blank paper, just typed up by the alleged vice president of loans, you know, that robo-signer designation. It doesn't even have an address. It had no phone number. And I put in a motion to dismiss based upon the fact that this document in no way certified. There's no jurat. Nobody even knows who signed it. It could just be drawn up by the attorney. And they're so corrupt down here, they're like, oh, no, that's okay. That document's fine, because it's prima facie evidence of, you know, they're possessing the note. It's just total crap. But I just share that with you because that's the kind of malarkey that they're working with here. So I did take it to the judge, and she just denied it.
Cindy does have that link and information on her site, on the State Attorney General site still today.
Cool. I'm going to check it out. I thank you for sending the email, and I'll bow out. I just wanted to share that with your listeners in case anybody else is in a foreclosure drama, you know? Yeah,
we've been dealing with that too, but also too, the state of Florida State Attorney General Pam Bundy still has that information in the lawsuit still on the front on her mortgage fraud cases on her page. So, I mean, the State Attorney General still has it on her page. She's had numerous cases. I know several people have dealt with her in their cases and have won. But it's doing it correctly, and part of the process is to make sure that these men and women have been served correctly.
Mm-hmm.
And that will even tell you through her own process, too, to do that. And they still have, she still has it listed as more than $1 billion in relief funding available for that.
What time frame was that, if you don't mind me asking?
Well, it's on right now. It's still on her site, and not only that, it has $2.1 billion state federal settlement with the bank foreclosures on her site, and this goes back to December 19, 2013, still active today.
Well, I'll look into that. All right, well, I won't take any more time up on that, but I just wanted to share that with you about the PMI aspect on the mortgage and how we kind of got to where we're at on it. Maybe that'll benefit.
And the title search companies, they have insurance on the title search on that as well. So, right, if I've got to do a little bit more research and come up with a little bit more stuff, I will do that and make sure it's posted correctly.
Yeah, and I'd be more than happy to contribute if we can on the claim and recoupment stuff after we have a better clarification of how it kind of rolls. All right?
No problem with that. No problem. It's like I said, it's all about education of of each other to make sure that we're doing this so that way we're protecting not only one another. And I'm not always into protecting public servants all the time, but sometimes they're not educated in some of the stuff they do. They just get instruction books, go by that without any further instructions. So, and that's sad because some of our public employees are put in position, and most of them do know the circumstances and do know that. And the one thing is that it's still existent too on the internet too is the Fannie Mae mortgage fraud structure is still up on the internet. You can type that in yourselves too. We do have that on our link on through the links when you open up on the mortgage on new.org and trackers. But it's still there. It's still active. And so that's the one thing that you can do the research. That's the whole point about educating. And also, too, it does get into the Florida cases on this with Florida 3rd District Court of Appeals foreclosure cases. There is numerous of them, and there is even an updated February 8, 2018 case on it right now.
Awesome, bro. Thanks a million. I appreciate all your hard work.
And that is on foreclosefraud.org.
Foreclosurefraud.org, yeah.
Yep. Number 4closurefraud.org. And that case just went through, like I said, February 8, 2018. So people are bringing these things in, bringing it up into the deal. Because I know one lady who got her house foreclosed when she was making all of her payments, never missed a payment, and they foreclosed on her because they wanted to put, what was that, a shopping center where her home was. So it was the argument that, we found out that's what they were doing, so we were able to bring the evidence in. So she not only got her home, but compensation out of it.
Nice. Well, we're looking to hold their feet to the fire. The bottom line is if you have a 90% chance of losing fighting the regular fight, what's your other alternative? And this is the only other thing we've come up with was using their own laws. But I like what you're talking about, and I do have to do a lot more reading. And I appreciate you sending that stuff over and everything you're doing.
No problem. Like I said, the stuff I sent you is there. I just opened it up right off our website to get back into it. It's all active. And including the structure for attorney Pam Bundy is still active on her site off our website.
Right. I got you. Yeah, I actually pulled that stuff up earlier. I just was having some challenges with the Apple right now.
Okay. So anyhow, so people comprehend that, we are working on this stuff to make sure that people have the knowledge out there. And so it gets confusing from everything on the points of view. And especially like what you're going through, too, is that you want to challenge them. You want to ask them where the certification is. You want to ask them, the other point, ask them to certify the debt.
Yeah, and I guess the point I was trying to convey to you, unless you come in as the plaintiff on these things as a defendant, they don't give you no respect. The judge just does not.
You want to ask them to certify the debt.
Okay.
Because you can't pay debt with debt, so what are they going to do? Doesn't that follow under Article 1, Section 10?
Yeah.
So, I mean...
I know you and I, we talked to Southern, and somebody down here has a case going, and I don't know if you ever got them on or not, but the dollar sign before the, 200,000 or whatever.
Yeah.
They're in court over what that dollar sign, what we call dollar sign above the number 4 on our keyboard means.
Right, yeah, no, I talked to Southern, and I know that he's working on that, yeah.
Yeah, so and basically you could come in with a bag of rice and go, here's your $224,000. Those are dollars. My definition is.
You know the coffee bean case then.
Coffee beans, maybe. Yeah, right.
Right, because coffee bean, Montgomery Ward versus, oh God, I'm having a brain fart. Yeah, the coffee bean case is Montgomery Ward versus Gene, and let me pull it up because I have it. So these are the points that, is bringing this stuff so people comprehend what these things are compared to what people think they are. And that is the whole point of walking through these mazes that we have been put through.
Right.
And once people comprehend that these things are there, available,
right,
then we don't have to argue so much as we go through arguing different things we shouldn't be arguing about.
Got you. Yeah, actually.
Wonderful.
That's a good point because that's exactly what they want to dilute you, distract you, and confound the facts to put you in a rabbit hole or 10, and then they have you chasing, hares.
Well, that's their job in a sense, and that's why people don't realize when they're going into these courts, they're administrative courts for the British Vatican Church. These things are run by the church in a lot of regards because you're going in and arguing your religious belief, and that's the point, is why are you arguing something that you have a right to, but knowing that why are you arguing to begin with when you should be able to produce your right, not argue your right.
Gotcha, bro.
And that's what I'm saying is bringing these things forward so they get to know. That's like what I was bringing up earlier in the conversation, or when I was just going on the path, is putting in the evidence. When you're putting into the corporation, you need to write the corporation's name. You want to put their VIN number, their DUNS number, their tax ID number, stuff like that in it, because once you start putting all that stuff in it, they can't sit there and go against their own structure. And if they go against it, that means everything else is a fraud. And so that's Montgomery Ward versus Eugene Gleiser case, the coffee bean case.
Okay.
And that's in the state of Michigan, the 52nd District Court, 3rd Division. That was done in, I think it was done in October 8th, 1982. And that's part of the reason why Montgomery Ward's folded up. Because they realized that people started paying their bills with coffee beans. And so, this is the one thing that putting these pieces together, and see, the thing is that I believe in purchasing your land from a landowner and being honorable. And
right.
It's done, not go through these mortgage companies where people are going to go fight and argue, and they go through things they don't even know half the stuff they're arguing about. Because, like I said, we all learn things new each and every day.
Right.
But that's one thing. And like I said, go to Pam Bundy's case. She's got some of this stuff literally on her state attorney general's site, because I know it's still up there because of two other people I know that still have pending court cases that they're trying to deal with. And I know another one that had a pending court case that proved that they took her land and closed it out when she didn't owe anything.
Yeah, that's not the first time I've heard that.
And so, but see, once you get this stuff, you want to certify your land. You want to make sure that you go after them to prove their point of view.
Right.
Once you could prove you could prove that they have no ownership, because I even have the laws, and even by federal banking laws, where banks can't own land.
Right.
So it's hitting them with their own. Well, I'm preaching to the choir on this one. Hit them with their own structure. Let them argue their own structure. It's that simple.
Right. I love it. Yeah. No, that's great. And this is the kind of information that needs to be disseminated for those who are not able to quite grasp it, and break it down to a 6th grade level, And so
Well, that's
Anything
why
I
I
can do to help?
movie Interstate 60, and I tell everybody to watch it at least twice. It explains your court system.
That's
Did you
the
ever
one on YouTube?
watch that yourself?
Is that the one on YouTube?
Yeah.
Okay, no, I just, after you said that today, I grabbed it to watch it tonight. I wanted to hear your call first.
Yeah, no, I mean, I recommend everybody watch that twice because it walks you through your court system in the maze, you know, and it's very interesting once you and it really explains when you're going into the court how they maneuver this structure in and their own oaths and stuff, and it actually really does this movie does a good job as far as I'm concerned. That's why I recommend twice, because when people watch it twice, they get it. So, anything else you got to throw in there before we move on to see if anybody else would like to add something?
No, thanks a million for your time. I just appreciate you clarifying. And the only other thing was, you know, when you walk into court and you're nervous and all this, you know, just the only thing I was going to ask you to share again was how, when they're like, state your name for the record, and how you came across, you know, as a man of the land. I like the way you put that. And then I'll check out. I'll mute myself.
Yeah, well, you know, you just want to say I'm here at special appearance. And, you know, because the other point you could always put that I was terrified if I don't show up, I could be assaulted and hurt and, you know, caged like an animal, and I'm a living man of this land. And so, and then you want to go with that you are a living, breathing man or woman of this land. And there's one other thing I'm missing right now, but I'll come up to that, and if not tonight, I'll bring it up next Saturday. But it is going, when you go into these courts, and mainly ask them the jurisdiction, and always file and ask the jurisdiction before you get there. And then when you get in there, when you're asking, when they call you're saying that you're here as special appearance, you don't want to agree to the term, you never want to walk through the bar gate, and I've done that. Oh, Ed, come on in. We won't assault you. We won't arrest you if you come in. You got my permission. Ah, stupid Ed does that. Stupid Ed goes to jail because he walked on the ship. And he knew better. And the judge is sitting there smirking because, hey, he lied to me. He walked in on the invitation of a dumbass. So, you know, those are things, don't put yourself in those positions. Like I said, I've done this and learned the hard way on this stuff. But you always want to put an affidavit in this structure to go through with that, to ask these questions of jurisdiction. That is the biggest point, knowing your jurisdiction. So, anyhow, if nobody else has got nothing else to say, I guess we'll just wrap it up this evening. So, if anybody pipes up, we'll go from there. And if anybody doesn't pipe up, okay, well, I guess what we'll do is we'll call it an evening. We would like to thank you for joining us, pass the knowledge around. You know, type up the court systems, how they work. Type up and make sure you read federal crime. You know, that's the one thing, is knowing how to file your thing under federal criminal activities. And I have that on the site. I've passed that around to people on that. And you've got to start reading this stuff, because when you go into these black robe courts, you know, you have to know this, where your standing is. These men and women already know their standing. And so when you don't know your standing, this is how they are getting this structure over you. So knowing how to read and start comprehending federal criminal procedure. Because once you comprehend that one, you know, and that is the Federal Procedure Manual. It is online. We know we post. I believe we have it on the internet. I put it in Facebook on our sites for record. I'll redo that again so it's a little further up instead of probably way down there. And then don't forget, you have the Policy Procedure Manual for federal grants and federal courts. These things are online. I do recommend that people get this, print them out or copy them, save them in files so you have it in case because they're always changing the internet today for the corporation's personal gain. I watched it where they've actually changed certain administrative rules and laws that they drop this or add that, but they still have to go by the original. So these are things that you are researching, so this way you don't end up in a bind. And then, like I said, we do have a lot of these videos on new Oregon tractors and on the mortgage structure of new Oregon tractors. And look at it. I mean, we've got, 2, 4, 6, 8 videos on that. We got federal civil forfeiture video that John Oliver did. Some of his stuff as a Brit is okay. At least he's a Brit that's honest on this HBO show, because he always says how the Britons still trying to conquer the United States, and he even admits that, yeah, we don't own the United States. The United States is not part of Britain. And that is the one thing that you need to start comprehending these things. So, like I said, you click on our links there. We've got a lot of stuff that are there. They are educational for you and your children. Your children are never too young to learn, and you could be surprised that your kids might realize or learn something faster than you do that brings something to you that you didn't see. And those are wonderful educational points. So with that, we'd like to thank everybody for joining us. We'd like to thank our producer for bringing up his knowledge and his kindness of what he does. And with that, I'd like to say, may the Great Spirit and Mother Earth bless you, and may the Creator overlook and protect you.
All participants are muted.
You have been listening to Education by Ed, which he just was a kiss ass to me, but effectively, what Ed brings to you is just education. Again, as we say, we are not lawyers, we are not attorneys, we are not any professional capacity whatsoever. We are just individuals, living men and women, that bring forth the knowledge that we have researched and found out ourselves. Anyone who takes what we teach or inform, we hold no liability for any of your actions. Anyone who speaks on the phone that is a guest, again, we take no liability for their views, opinions, or actions. So, with that, we will catch you this coming up Saturday, and it'll have another interesting and nail-biting subject to talk about. Thank you very much, and have a good week.